but at the
For
last
motion,
adjourn
please.
for motion.
Yes.
I'm grateful, sir. I take the hint. My Lord, sir, we have an application before the court. We are praying the court to strike out some of the defendants in the matter. The application is dated the 30th of March 2025, but filed on the 4th day of March, 4 March 2025. If the court is minded, we are ready to move that application this month, sir.
Okay. Any objections to the movement of the application?
We are yet to get any counter affidavit in the court's file.
My Lord, sir, we served the application on the claimant on the 4th day of March, 4 March 2025. That's well over a year ago. And then I can assume that if as a date, after more than a year, they have not responded, it means they are not opposing our application. So I'm ready to move, say, if the court is willing to take us, sir.
Yes.
I'm grateful, sir. My Lord, our application is dated the 3rd day of March 2025, but filed the following day. It is brought pursuant to sections 251, subsection 1, paragraph B and I, as well as section 254C of the Constitution of the Federal Republic of Nigeria, 1999 as amended. Section 7, subsection 1 of the National Industrial Code Act, 2006. Section 7, subsection 1, paragraph I of the Federal Court Act, as well as Order 13, Rule 14, Sub Rule 2 of the Rules of this Court, 2017. And under the inherent jurisdiction of your Lordship, sir, our application principally prays the court to strike out the names of the 3rd, 5th, and 6th defendants. That's our prayer one. Number 3, number 5, and number 6 defendants. As well as the defendant number 1, 3 to 7. Your Lordship, sir. If I have the hint of the court to go ahead.
Yes, go ahead.
I'm grateful, sir. I'm grateful, sir. My Lord, in support of the said application is a 5-paragraph affidavit sworn to by one Joseph Umoren. Umoren is spelled U-M-O-R-O-E-N, a litigation manager in the law firm to counsel to the 1st to 7th defendants applicants. We rely on all the depositions in the said affidavit deposed on the 4th day of March, 4 March 2025. In compliance with rules of this honorable court, we also filed the written address. It's filed on the said 4th of March, 4 March 2025, even though it is dated the 3rd day of March 2025. We adopt the submissions therein in urging your Lordship to strike out the names of the 1st, 3rd to 7th defendants. In closing, my Lord, our basis basically for praying the court to strike out the defendants are that one, the third to seventh defendants are co-employees of the claimant or were co-employees of the claimant, against the background that by this suit, the claimant seeks to require or request your lordship to declare unlawful or wrongful his termination by the second defendant. So the basis upon which we pray the court to strike out these employees are because, one, they are employees of the second defendant who the claimant in his averments, as we read out in the affidavit, declared that these individuals are his co-employees. He was employed by the second defendant. He was paid through the period by the second defendant, and he was terminated by the second defendant. So on that basis, we prayed the court to strike these defendants out because their presence are not only unnecessary, but unwarranted. Finally, sir, we also prayed your lordship to strike out the name of the first defendant from the suit because by the averment of the claimant himself and the document he exhibited, that is his letter of employment, his letter of promotion, his letter of termination, his payment slips, and after termination, his letter of appeal for reinstatement were all addressed to the second defendant. For letters issued, like the letter of employment, termination, confirmation of employment, they were issued by the second defendant. And for payments, evidence of payment of salaries made throughout the period, they were payment slips made by the second defendant. The first defendant has no nexus whatsoever with this suit. And we are craving the court that there is no need making them pay in man hours and counsel fee to participate in the trial of this suit. As I wrap up, I also want to bring a second dimension of the reason we are praying your lordship to strike out these parties. And it is in relation to the claimant's paragraphs 32, 33, and 34 of his statement of facts. By the averment in those paragraphs, the claimant is asking your lordship to summon the third, fifth, and sixth defendants, 3, 5, and 6 defendant applicants, to come and please present their tax clearance certificates, their immigration visas and passport, in fact, immigration documents. And they founded the reliefs 5 and 6 in their reliefs 5 and 6 on the said averments. In effect, the claimant's goal is that at the end of the suit, they want your lordship to compare the third, 5, and 6 defendants to present their visa permits before the court for inspection, as well as to present their tax clearance certificates, etc. Our argument is that matters of visas issuance tax payment, tax certificate, tax clearance, issuance, compliance, etc. They are matters outside of your lordship's jurisdiction, respectfully. They are not matters bordering on employer, employee, as the claimant has brought before your lordship. So on these grounds, and fuller orders in our document, in our motion or notice, we are respectfully urging your lordship to strike out the first, the third, fourth, 5, 6, and 7 defendant applicants, because this suit can be determined on the merit with just the second defendant alone, who was the employer, whom in our assessment the claimant has a grouse with, and the second defendant is still a going concern. Whatever is the outcome of your lordship's judgment, the second defendant has the requisite capacity to respond. So we thank the court for the opportunity to make our submissions, and respectfully urge your lordship to relieve these other defendants of the burden of going through the hog of trial of the suit. They are being harassed, in our opinion. We are grateful, sir, and then we thank the court for the indulgence and for taking out time to painstakingly listen to us. I'm grateful, sir. We thank the court.
Mm-hmm. Yes. Can you hear me?
Yes, my lord. In the circumstance, my lord, in view of the fact that our motion has been taken, may we now crave the court for a date for ruling on our motion on notice just taken.
All right.
Sir. I'm grateful, sir.
All right. Give me a date.
17th of June.
Just a moment, sir.
Is that okay?
17 June is not convenient, my lord. If I can have another date. I'm sorry, sir.
18th.
18th is very convenient. It's a Thursday. It's
Below
convenient.
June 18th.
All right. Matter adjourned to the 17th of June, 2026.
18th June, my lord.
18th
18th June, my
of
lord.
June. 18th of June.
I'm grateful, sir. We thank the court, sir. I wish
All
my
the
lord a
nice-
very beautiful day.
Thank you. You too. You too.
Yes, ma'am.
Yes, I can call the next case, please.
Number NICN/LA/439/2017 between Mr. Olufemi Olatosi and one BHI Holdings Limited and 7 others. The Lord claimant in court, defendant's absence.
Yes.
With profound respect to this, honorable court, I am
Yes.
Omekunle for the claimant.
Okay. Who is for the defendants?
The defendant counsel is absent.
The Lord, there is
All
an
right.
adjournment letter from the defendants.
My
Okay.
lord, I want to speak concerning the letter. Today's matter was slated for continuation of trial for cross-examination and defense. I would like to address the court on the letter that was sent. Okay. A letter was sent on behalf of the defendant seeking an adjournment of today's proceedings. My lord, we urge this
All
honorable
right.
court in the strongest possible terms to discontinence this letter in its entirety. Firstly, my lord, the said letter is fundamentally defective and undeserving of any judicial consideration. It was not written or signed by a non-legal person before this honorable court. Yet, it bears a stamp and the seal of a lawyer. This raises serious questions as to its competence and propriety. A process unknown to law cannot be the basis for invoking a court discretion. Secondly, my lord, the timing of the letter is most telling. It was delivered to my WhatsApp yesterday about 5 p.m. on the eve of the proceedings. Parties had previously agreed on this date of continuation of trial. This 11th hour request is clearly an afterthought, calculated to obstruct the smooth administration of justice.
Yes.
Thirdly, my lord, the excuse proffered here is hollow and unsubstantiated.
I didn't get that last part.
I said, the excuse proffered in the said letter is hollow and unsubstantiated. The excuse is unsubstantiated. The defendant counsel claims to have another matter in mind. Yet no particulars are supplied. No suit number. No court. No evidence of engagement. My lord, this honorable court is being invited to act on bare assertions which ought not to be countenanced. I pray this court that my lord, this application is not made in good faith. It is a continuation of long-standing pattern of delay. This matter, my lord, was instituted as far back as 2017. Since then, the defendant has consistently taken steps to frustrate his expeditious determination. Cost has been awarded against them in the past, which remain unpaid till today. This demonstrates a clear disregard for the authority of this honorable court. My lord, my lord.
Hello, my lord.
Yes.
Okay.
Can you hear me?
Yes, Your Honor, Your Lordship.
Can you hear me now?
Yes, Your Lordship.
My speaker is malfunctioning.
Oh, okay.
Yes.
This matter, my lord, was instituted as far back as 2017. Since then, the defendant has consistently taken steps to frustrate its expeditious determination.
All right.
Cost has been awarded against them in the past, which remain unpaid till date.
Okay.
Demonstrating a clear disregard for the authority of this honorable court. My lord, today's proceedings are for continuation of trial. The claimants or
Yes.
witnesses in court, ready for cross-examination. The defendant who ought to cross-examine and proceed to open their defense is absent and has chosen to send an incompetent letter instead of appearing before this honorable court. My lord, litigation is not a game of hide and seek.
How many witnesses do you have?
One,
How many do they have?
I think they have up to two. They have two witnesses.
Aquan, give me 2 clear dates. Aquan, have you heard me?
July 1st and 2nd.
Is that convenient?
We're praying for the court for earlier dates in June.
That's the earliest date that we have.
Okay, July 1st is convenient. First and second, right? It's convenient, Your Lordship.
Okay. This matter is adjourned for definite hearing. All the parties are ordered to bring forth their witnesses on the 1st and the 2nd day of July 2026 for a definite hearing.
As copy,
Your Lordship.
Yes. Call the next case.
Suit number NICN/LA/183/2022 between Inspector Okuku Kenny and Megamon Investment Company Limited. My lord, the matter is for trial. Are parties in court? No parties are absent.
All right. Yes, counsel.
Lord, since there is no counsel.
All right. Move to the next case.
July 9, my lord.
All right. Send them a
July.
hearing note for the 9th day of July.
Yes, my lord.
Call the next case.
So number NICN/LA/359/2023 between Mr. Adeboye Adetayo and Sako Insurance PLC. Lord, the matter is for trial. Are parties in court? No parties are absent.
Okay. Counsel, give me your appearance.
Seems there is no council, my lord.
Yes, okay. Give me a date.
July 15th, my lord.
All right. Hearing notice is ordered to be served on all the parties for a hearing on the 15th day of July 2026.
As God places.
Yes.
Sorry,
Call them.
my lord. I'm sorry to interrupt the proceedings.
Mm.
I've joined this court session since 10 a.m. And my matter is number 3 for ex parte motion. Don't know whether it has been called or it was skipped.
No, it was called that you
Number
are
3.
not here.
No, my lord, maybe it's network. I've been here since 10 o'clock.
Okay.
My
What
matter
is your ex parte for?
is a Ganishi proceeding for the night time.
All right. Call the case, Akpan.
Please.
Suit number NICN/LA/28M/2026 between Mr. Albert Ike and one Chikason Group of Companies Limited and AZ Petroleum Products Limited. My lord, say Kanishi proceeding.
All right.
Parties are absent. Parties are absent, my lord.
Yes. Counsel, give me your appearance.
With utmost respect to the honorable court, I am H.O. Ndubisi, H.O. initials, Ndubisi, as pronounced. My appearance is for the judgment creditor applicant.
All right.
My lord, I have before the honorable court this morning a motion ex parte dated and filed on the 27th day of February 2026. My lord, subject to the overriding convenience of the court, we're ready to proceed with our motion ex parte.
Yes, go ahead.
My lord, our motion ex parte is going to brought pursuant to section 83(1) and 2
Don't
of the
worry,
Sheriff
just
and Civil
move it
Process
out of your application, counsel.
As the court pleases. My lord, with the kind permission of the court, I move in terms of the motion paper dated and filed 27th day of February 2026 and urge the honorable court to grant them as prayed. I'm most grateful to the court. Very well, my lord. That is our motion.
All right. The application moved is granted as prayed for an order 90.
As the court pleases.
There is a motivation for the return for all the garnishes that are named in this court. So, Akwan, give me a date.
Yes, my lord. Lord, 2nd of June.
2nd of June. My lord, I'll take it. 2nd of June is
the 2nd of June 2026 for hearing of the garnishes.
As the court pleases. Most grateful to the court for the kind indulgence. Most
no
grateful
problem. Thank you very much, Mr. Indemnity.
As the court pleases.
Yes, call the next case.
Lord, that will be all for today.
All right. Very well then, gentlemen. Thank you very much.
Thank you,
Have a
my
very
lord.
nice day.
For this proceeding. We are grateful to the court.